Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? No matter the month or year, employers can count on one thing: changes in workplace law. Having reached the midway point of the year, 2024 has proven to be no exception, with many significant changes and potential challenges ahead for employers. What follows is one of a collection of concise programs as We Get Work the podcast provides the accompanying voice of the Jackson Lewis 2024 Mid-Year Report, bringing you up-to-date legislative, regulatory, and litigation insights that are taking place now, and what you can expect next in the second half of this year. We invite you and others at your organization to experience the report in full on jacksonlewis.com or listen to the podcast series on whichever streaming platform you turn to for compelling content. Thank you for joining us.
Hi, this is Catherine Weber with Jackson Lewis's Cincinnati office, and I'm joined today with Eric Magnus from our Atlanta office. For those of you who don't know Eric is a guru when it comes to all things wage and hour and all things class and action. And Eric is here to talk to us a little bit about the Transportation Workers Act exception that's included in the FAA. Now, Eric, we had a big case in April of this year that involved some folks who said that, look, I am a transportation worker under the FAA, and therefore you cannot make me arbitrate my claims. Tell us a little bit about that case and what the court said.
Yeah, so had the outcome been different, it would have been very, very surprising. But the outcome of this case was, I would say, a reaffirmation of the Saxon Southwest Airlines decision Supreme Court had issued a couple years back. There have been 2 transportation worker exception decisions in the last 3 years, and it's probably not the last one. So the general issue here is the Supreme Court has been very clear in its directives over the last 15 years to employers that the FAA's reach is very, very broad. Employers are allowed to have arbitration agreements that are covered by the FAA. And what's important about being covered by the FAA is that the FAA preempts a lot of the challenges that we used to see to arbitration agreements, like state law, substantive and procedural unconscionability arguments, like a state that may say that a class action waiver is procedurally unconscionable. All of those sort of arguments are preempted by the FAA. So being covered by the FAA is very important for the enforceability of an arbitration agreement.
But of course, transportation workers exception, though, if that applies, that basically scoops those workers outside the context, right?
So that's the import of the transportation worker exception is anyone who is quote unquote a transportation worker isn't covered by the FAA. So obviously, to your point, Catherine, the issue is always, well, what is a transportation worker? And that's the issue in all these cases. What the bakery wanted to argue is that we're a bakery and therefore we're not in the transportation industry. So therefore, there's no way we could be covered. Anyone that works for us could be covered by the transportation worker exception, period, end of story. They're sort of arguing that the exception was designed for the transportation industry, quote unquote, what that means. So, obviously they would say that's truck drivers, that's railway employees, that's people that work on airplanes, things that are obviously the transportation industry. That ain't a bakery.
That sounds like a nice clean-cut test, though, right?
Sounds like a nice argument if it worked, but it didn't work. What the Supreme Court held is that whether an employee is a transportation worker is based on the employee or the class of jobs that the employees do. It is not based on what the company does. What the Supreme Court held is that it doesn't matter what the business of the company is. What matters is whether the class of workers in question are doing transportation. And that has a definition under the FAA as well. We're really talking about people who are actively engaged in interstate commerce, bringing goods across borders via the channels of interstate commerce. You don't have to actually be the person doing it. And that was decided in the Saxon case, the Southwest Airlines case, because that was about ramp agents working for Southwest Airlines. But those people are clearly engaged in the process of flowing goods across state lines. And what the Supreme Court held is that that's what matters, is whether the class of workers, not what kind of company do you work for. And that's effectively the ruling that we got in the Bissonnette case.
So they did not go for the nice, clean, clear, easy to understand rule of if you're a transportation employer, then that's all that matters. And instead, now we're just looking at the work or the type of work that the employees actually perform, regardless of what industry type of employer they work for, right?
Correct. And you and I would like to argue that the test that they were arguing for was clean cut, but it actually isn't, because if the court would have gone the other way, the debates would have become, well, what is the transportation industry, right? So you could start making arguments that, the type of arguments we hear Uber and Lyft make, right? Uber and Lyft make arguments, those type of companies make arguments that we're not in the business of transporting people via ride shares. We're just a tech app company that contracts with people who then do the ride sharing, right? So you can get into all kinds of interesting discussions about whether you're in the transportation industry. That debate would have been probably equally as divisive. Like, I saw this argument laid out there in one of the amicus briefs. You could make an argument based on revenue that we don't have a single airline in the business of airlines. They're all in the credit industry. They make more from their credit card clubs than they do from the selling of actual airline tickets. So this was one of the arguments that were made in the briefs. So I thought it was great. Even the most obvious, quote, transportation industries have arguments that they're actually not in the transportation industry. So I don't know that it would have saved any spilled ink by going the other way. We would have liked to argue it did. It's probably easier to advise clients, but I don't know that it would have still caused massive amounts of litigation going forward.
Well, now that we have the clarity that the Supreme Court brought to us in the Bissonnette case, so what should employers be thinking about in light of this?
So the best advice, if you've got workers that you want to be subject to arbitration agreements that could even conceivably be conceived as transportation workers, right? Like they're somehow related to the transportation of goods across state lines. If you've even got that as possible, the best advice I give clients is that you want to amend your arbitration agreements to have what I call a state law backdrop. What a state law backdrop is we have a provision that says if the FAA does not apply, then you choose an arbitration. Every state in America has an arbitration act. So you choose the applicability of one of the state arbitration acts. In most states, that's going to allow you to enforce the key provisions of your arbitration agreement. It doesn't give you the same sort of blanket preemption of every argument that a plaintiff's lawyer can make to try and strike at the enforceability of the arbitration agreement, but it does give you a means of enforcing your arbitration agreement that even if the worker is deemed a transportation worker under the FAA, you still have the ability to move to compel arbitration and arbitrate and enforce all the provisions of your arbitration agreement. So that's the best prospective advice I can give, is to have the backup plan in case you have some worker that is construed to be a transportation worker, and construe it in the broadest way you possibly can so as to cover yourself.
So actually, Eric, what I heard from that is if there's anybody that works for you, if you're an employer that uses arbitration agreements and there's any employees that you want to be covered by that arbitration agreement who could arguably, possibly ever be considered a transportation worker, then those folks need to reach out to you so that they can make sure that they're taking a good hard look at the different state arbitration acts and making good choices in the drafting of their agreements.
That would be good advice, yes.
All right. Well, thanks, Eric. I think you've answered all my questions.
Great. Pleasure.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.